Does pregnancy make a difference in a J1 exceptional hardship waiver case? That is one of the things we're going to be talking about in this case study for our J1 waiver series. So stay tuned. My name is Kaushik Ranchod. I represent clients across the 50 states, and we are going to deep dive into this case study. So the J1 waiver exceptional hardship is for you if, first of all, meet the basic requirements of having qualifying relatives. So you have to have a U.S. citizen spouse or a lawful permanent resident spouse, or you have to have a U.S. citizen child or lawful permanent resident child. Those are the basic requirements. Now, why do you need the 2-year home residency requirement? Well, if you came in on the J1 visa program and you're subjected to the 2-year home residency requirement, which could be a variety of reasons. For instance, you could be a physician in a residency program. It could be because of the skills list. It could be because your government gave you financing, whatever the reason. And one way to tell is looking at your DS2019 and see if you're subjected. Then you're going to either need to go back to your home country for 2 years, or you're going to need the waiver. All right, let's talk about the process. What is involved with filing the J1 waiver? It is a long process right now. It is taking anywhere from about 1 year and 7 months to 2 years or longer to get the J1 waiver. So that's why I advise that you apply as soon as possible so you can get, depending upon your situation, of course, so you can get the ball rolling. These processing times do change, but what I'm noticing is that the J1 waiver has been staying about the same. I haven't seen much progress either way. With other case types, I actually am seeing an increase in processing time. So I'm hoping that that's not going to happen with the J1 waiver. So the sooner that you file, the sooner you get yourself in the queue to have your case reviewed. The process entails filing the DS3035. We normally then file the I-612. That's the form, but it's not just the form. This is one of the most complicated areas of immigration law. So what we do is we file a detailed legal brief. A lot of times we see people who have tried to do it themselves or hired someone who doesn't know what they're doing, and that's because they weren't able to demonstrate exceptional hardship, or they just did a statement that didn't really demonstrate the exceptional hardship. What we do is we prepare a detailed legal brief explaining all of the hardship waiver arguments, and we're going to talk about how we did that in this case. Yes, it is possible, so let's talk about how we did it. Well, in this situation, we filed the case with USCIS. USCIS then sent it over to Department of State. Department of State reviews the case, and then USCIS issued the final approval. And the reason they did that in this case was because our client is a US citizen. Our client entered the United States. They're from a Latin American country, and they met and fell in love with their U.S. citizen spouse. So that U.S. citizen spouse in this case is the qualifying relative. In this situation, the wife was expecting to have a child only 2 weeks after the applicant would have to leave the United States. So we made the argument that this was a form of exceptional hardship. Now, although having a child on the way, if you're pregnant, that in and of itself doesn't qualify as a qualifying relative, we have noticed in our cases that USCIS is taking this into significant consideration. Also in this case, we also argued emotional hardship, especially because the wife was pregnant, and if they were separated in this situation, the couple would face severe emotional hardship because they just had a baby. So of course, if you're separated from your spouse, it's going to be devastating. We also argued financial hardship. The wife did work, but the husband was the main breadwinner for the family, so she would not have enough income if the husband left to the home country. And then we also argued that the health insurance was through the husband's employer, so she would lose the health insurance as well for herself and her baby. We also argued that the wife couldn't accompany the husband to the home country because she didn't speak the language. There was a language barrier there, and because of that, that was another form of exceptional hardship. We also argued as well that she couldn't continue her career abroad, and that also ties into the language barrier as well. So we made all of these arguments to demonstrate exceptional hardship, and we are grateful that we were able to get the case approved, and we're so happy that we were able to keep this family together in the United States, because that's our goal, unification. I hope you enjoyed this video. Thank you for taking the time to better yourself. By bettering yourself, you're bettering your family. By bettering your family, you're bettering the world. Thank you. Bye for now.